I knew something was wrong the moment I saw Karen Ashford standing at my front door with a clipboard, her perfectly styled blonde bob not moving an inch in the spring breeze that swept through my neighborhood in Henderson, Nevada. It was a Saturday morning in late March, and I had just finished painting my fence a beautiful shade of sage green that my wife had picked out after weeks of deliberation. "Can I help you?" I asked, wiping paint from my hands onto an old rag. Karen's smile was tight, forced. "Marcus Johnson, I presume?" "I'm Karen Ashford, president of the Silverstone Heights Homeowners Association. I'm afraid we have a rather serious issue to discuss." I had lived in this neighborhood for 3 years, and while I knew we had an HOA, they had never bothered me before. I paid my dues on time, kept my lawn maintained, and generally stayed out of everyone's business. "What kind of issue?" She gestured toward my newly painted fence with one manicured nail. "That color is not approved per our HOA guidelines." Section 4.2, subsection B clearly states that all exterior fence colors must be either white, beige, or light gray. This green is a direct violation. I felt my jaw tighten. My wife, Sarah, and I had spent nearly $2,000 on this fence project. We had carefully selected the color to complement our desert landscaping and the natural tones of our stucco home. I never received any notification that I needed approval for fence colors. "Ignorance of the rules doesn't excuse violation of them," Karen said, her voice taking on a condescending tone that made my blood pressure rise. "You have 7 days to repaint the fence to an approved color, or we'll begin fining you $500 per day until compliance is achieved." $500 a day. I couldn't believe what I was hearing. "That's insane." "Those are the rules, Mr. Johnson. You signed the HOA agreement when you purchased your home." She handed me a formal notice from her clipboard. "This is your official warning, 7 days. After she left, I immediately went inside and dug out the massive stack of papers from our home purchase. Sarah came into the kitchen, concern etched on her face. "What did she want?" "The fence color," I said, flipping through pages. "Apparently it's not approved." Sarah's face fell. "But we spent so much time choosing that color. It's perfect with the house." I finally found the HOA documents, a thick packet that I admittedly had only skimmed 3 years ago during the chaos of moving. As I read through the covenant conditions and restrictions, something started to feel off. The document was dated 1998, almost 30 years ago, and many of the provisions seemed outdated or vaguely worded. The section Karen mentioned about fence colors existed, but there was something else that caught my attention. The HOA's authority was derived from a declaration that referenced specific Nevada state statutes. I wasn't a lawyer, but I had a friend from college who was. I grabbed my phone and called Derek Matthews, who practiced real estate law in Las Vegas. "Marcus, how are you?" Derek answered on the 3rd ring. "Been better. I've got an HOA problem." I explained the situation while Sarah listened intently, her arms crossed. Derek was quiet for a moment. "Send me pictures of the fence and a copy of your HOA documents, all of them. I want to look at something." I spent the next hour scanning and photographing everything, then emailed it all to Derek. He called back within 2 hours. "Marcus, I think you might have a case here," Derek said, and I could hear the excitement in his voice. "Your HOA's governing documents reference Nevada revised statutes that were actually amended in 2015. There were significant changes to HOA authority that year, and unless your HOA updated their governing documents, which it doesn't look like they did, they might not have the authority they think they have." "What do you mean?" The 2015 amendments limited HOA power over certain aesthetic decisions, particularly when it comes to reasonable modifications that don't affect property values or neighborhood uniformity. Your fence color is subjective, and if they haven't properly updated their legal foundation, they can't enforce these older, more restrictive rules. Plus, I see no evidence in these documents that they properly registered the amendments or held the required votes to maintain these restrictions under current law. My heart started racing. So what do I do? First, don't repaint anything. Second, let me draft a response letter. If they push this, we might need to go to court, but I think we can win this, Marcus. This could actually be a really important case for HOA reform in Nevada. Over the next week, Derek sent a formal legal response to the Silverstone Heights HOA, explaining that we were disputing their authority to enforce the fence color restriction. Karen's response was swift and aggressive. Within days of receiving Derek's letter, I got a notice that I was being fined $500 per day, effective immediately. They're not backing down, I told Sarah as we sat at our kitchen table, staring at the fine notice. They've already racked up $3,000 in fines. Can they actually make us pay this? Sarah asked, her voice worried. According to Derek, they can try, but he says we shouldn't pay until this is resolved. If we pay, it could be seen as accepting their authority. The next HOA board meeting was scheduled for the following Thursday evening at the community center. Derek advised me to attend and speak during the homeowner comment period. I was nervous as Sarah, and I walked into the meeting room. About 40 other residents were there, most of them looking bored or resigned. Karen sat at the front table with 4 other board members: Patricia Nelson, Robert Chang, Margaret Wilson, and Todd Henderson. They looked like they took themselves very seriously, with name placards and a gavel that Karen wielded like a weapon. The meeting dragged through mundane business: landscaping contracts, pool maintenance schedules, and budget reviews. Finally, we reached the homeowner comment period. I stood up, my hands slightly shaking. My name is Marcus Johnson. I live at 4521 Desert View Drive. I want to address the fence color issue. Karen's expression hardened. Mr. Johnson, you are currently in violation of HOA covenants and have accumulated significant fines. Unless you're here to inform us of your compliance plan, I'm not sure there's much to discuss. Actually, there is, I said, feeling Derek's coaching kick in. I've had an attorney review our HOA's governing documents and the applicable Nevada state statutes. It appears that your authority to enforce aesthetic restrictions like fence colors may not be legally valid under current law. The room suddenly got quiet. Other homeowners looked up with interest. Patricia Nelson, the vice president, leaned forward. That's absurd. We've been enforcing these rules for years. Enforcement doesn't equal legality, I replied. Nevada made significant changes to HOA law in 2015. Your governing documents haven't been properly amended to comply with those changes. Until they are, you don't have the authority you claim to have. Karen's face flushed red. This is ridiculous. You're trying to weasel out of rules that every other homeowner follows. Actually, a voice spoke up from the back. I turned to see an older man standing. I'd like to hear more about this. I've been fighting with the HOA for months about solar panels, and they keep citing old rules that I don't think apply anymore. Another woman stood. And they rejected my request to paint my front door navy blue, even though there are already 3 houses in the neighborhood with non-standard door colors. Karen banged her gavel. This is not a forum for airing grievances. Mr. Johnson, your fines stand. If you don't comply, we will place a lien on your property. I wouldn't recommend that, I said calmly. My attorney is prepared to file suit if you continue this enforcement action. Then file, Karen snapped. We'll see you in court. The meeting ended in chaos, with several other homeowners approaching me to ask about my lawyer. I exchanged contact information with 6 different people who all had their own HOA disputes. The solidarity felt good, but I knew we were in for a fight. 2 weeks later, Derek filed a lawsuit in Clark County District Court. The case was Marcus Johnson v. Silverstone Heights Homeowners Association, and we were seeking a declaratory judgment that the HOA lacked authority to enforce their aesthetic restrictions under current Nevada law. We also sought an injunction preventing them from collecting the fines they had imposed. The HOA hired an attorney, a stern-looking man named Richard Pemberton, who represented multiple HOAs across the Las Vegas Valley. The case started moving through the court system, which I quickly learned meant it moved at a glacial pace. Meanwhile, life in the neighborhood became increasingly uncomfortable. Karen made a point of walking past my house regularly, always stopping to take pictures of my sage green fence. Some neighbors avoided eye contact with me, clearly not wanting to get involved. But others were supportive, with 3 of them even painting their own fences different colors in solidarity. One went with a soft blue, another chose a warm terracotta, and a third picked a cheerful yellow. Karen lost her mind. Within a week, all 3 of those homeowners had violation notices. 2 of them joined our lawsuit as additional plaintiffs. The discovery phase of the lawsuit was revealing. Derek subpoenaed all of the HOA's governing documents, meeting minutes, and financial records. What we found was troubling. The HOA hadn't held a proper annual meeting in 4 years. Financial audits were incomplete, and Karen had been approving expenses without board votes, including paying herself a monthly administrative fee of $800 that wasn't authorized in the budget. "This is bigger than your fence," Derek told me during a meeting at his office in downtown Las Vegas. "This HOA has been operating outside its legal authority for years, and they've been financially mismanaged as well. What does that mean for our case?" "It means we have them on multiple grounds. Not only do they lack authority for aesthetic enforcement under current statutes, but they haven't been following their own internal procedures either. A court could potentially invalidate years of their actions." We amended our lawsuit to include claims about the HOA's governance failures and Karen's unauthorized compensation. The local news picked up the story, and suddenly, I was doing interviews with Channel 8 News about HOA overreach. The day of the preliminary injunction hearing arrived in late June. The courthouse was busy, and I felt out of place in my suit and tie, sitting next to Derek at the plaintiff's table. Karen was there with Richard Pemberton, looking confident and self-righteous. Judge Raymond Foster entered the courtroom, a distinguished man in his early 60s with gray hair and sharp eyes. Everyone stood, and then we began. Derek argued first, laying out our case that the HOA's governing documents were based on outdated statutes, and that they hadn't followed proper procedures to maintain their enforcement authority. He presented evidence of the 2015 statutory changes, and explained how the HOA had failed to amend its declarations accordingly. Pemberton argued that HOAs had broad authority to enforce their covenants regardless of statutory updates, and that homeowners agreed to these restrictions when they purchased their properties. Judge Foster listened carefully, occasionally asking questions. Then he turned to Karen, who was listed as the HOA representative. "Miss Ashford, when was the last time your HOA's governing documents were reviewed by an attorney?" Karen hesitated. "I'm not sure, Your Honor, before my time as president." "And when did you become president?" 6 years ago. 6 years, and you never had an attorney review your legal authority?" Judge Foster's tone was skeptical. "We have an attorney," Karen said defensively, gesturing to Pemberton. "Mr. Pemberton, when did you begin representing this HOA?" the judge asked. "3 weeks ago, Your Honor, when this lawsuit was filed." Judge Foster leaned back in his chair. "So for 6 years, this HOA has been operating without legal guidance, enforcing restrictions based on decades-old documents, and imposing significant fines on homeowners without verifying their legal authority to do so. Is that correct?" Pemberton cleared his throat. "Your Honor, many HOAs operate with minimal legal consultation. It's common practice." "Common doesn't mean correct, Counselor." Judge Foster reviewed his notes. "I'm inclined to grant the preliminary injunction. The plaintiffs have raised serious questions about the HOA's legal authority, and I see no compelling reason why they should be forced to pay thousands of dollars in fines while this matter is litigated." Karen stood up abruptly. "Your Honor, if you allow this, it will set a precedent that homeowners can ignore any rule they don't like." "Sit down, Miss Ashford," Judge Foster said firmly. "You'll have your opportunity to present evidence at trial. But based on what I've seen today, I have significant concerns about your association's legal foundation." He granted the injunction, stopping all fines immediately and preventing the HOA from taking any enforcement action against my fence or the other plaintiffs' properties. Walking out of the courthouse, I felt victorious, but Derek warned me this was just the beginning. The trial was scheduled for September, which gave both sides time to prepare. The HOA finally brought in expert witnesses, including an HOA management consultant, who testified in his deposition that Silverstone Heights had numerous procedural deficiencies. Derek deposed Karen for 6 hours, and she did not perform well under pressure, contradicting herself multiple times and admitting she had never actually read the Nevada revised statutes governing HOAs. Summer in Henderson was brutally hot, with temperatures regularly exceeding 110 degrees. My sage green fence looked beautiful against my desert landscaping, and I made sure to maintain my property impeccably. I wasn't going to give Karen any other ammunition. The local news continued following the story, and I started hearing from homeowners across Nevada who had similar issues with their HOAs. Some of the stories were heartbreaking, elderly people being fined thousands of dollars for minor infractions, families threatened with foreclosure over paint colors or mailbox styles. The case was becoming bigger than just me. A week before trial, Pemberton reached out to Derek about a settlement. The HOA was willing to drop all fines and allow my fence to remain if I dropped the lawsuit. "What do you think?" I asked Derek. "It's your decision, but I think we should go to trial. This isn't just about your fence anymore. If we win, we could change how HOAs operate throughout Nevada. We could help a lot of people." I talked it over with Sarah that night. "It's been stressful," she admitted, "but I keep thinking about that elderly man who came up to you after the meeting, the one being fined over his solar panels. If we settle, nothing changes for people like him." "So we keep fighting," she nodded. "We keep fighting." I called Derek the next morning and told him no settlement. We were going to trial. The trial began on September 15th, a Tuesday morning that started with partly cloudy skies that later burned off into typical desert sunshine. The courtroom was packed with local homeowners, several reporters, and even a representative from a statewide homeowner rights advocacy group. Judge Foster presided, and we went through jury selection. 12 ordinary citizens, ranging from a retired schoolteacher to a young software engineer, would decide our case. Derek's opening statement was powerful. He explained how HOAs were supposed to protect property values and maintain communities, but had instead become mini dictatorships that operated outside the law. He laid out our evidence that the Silverstone Heights HOA's governing documents were legally deficient and that the organization had been mismanaged for years. Pemberton's opening argued that HOAs needed strong enforcement power to maintain neighborhood standards, and that allowing homeowners to ignore covenants would lead to chaos. He painted me as a troublemaker who didn't want to follow the same rules as everyone else. The first witnesses were homeowners from Silverstone Heights. Derek had prepared them well. They testified about arbitrary enforcement, where some violations were ignored while others were aggressively pursued. One woman described how Karen had approved her neighbor's fence modification that violated the same rules Karen was using to fine me. Then we had the expert testimony. Derek brought in Professor Elizabeth Morrison from Unlv's Law School, who specialized in property law. She walked the jury through the 2015 statutory changes in Nevada HOA law and explained how associations were required to update their governing documents to comply. Did Silverstone Heights HOA update their documents? Derek asked. No, they did not, Professor Morrison said clearly. Based on my review of their declarations and bylaws, they're still operating under authority granted by pre-2015 statutes that have been significantly modified or replaced. What does that mean for their enforcement authority? It means many of their restrictions, particularly aesthetic restrictions like fence colors, are likely unenforceable under current law. The 2015 changes specifically limited HOA authority over these types of subjective aesthetic decisions, recognizing that they were being used in arbitrary and discriminatory ways. Pemberton cross-examined her, trying to suggest that the old documents still had some validity, but Professor Morrison was unshakable. The law was clear. The HOA's witnesses didn't go well for them. Their property management consultant admitted under Derek's cross-examination that Silverstone Heights had failed to follow best practices in numerous areas. Their financial expert confirmed that Karen's self-approved compensation was not properly authorized. Then Karen took the stand. Pemberton tried to present her as a dedicated volunteer trying to maintain neighborhood standards, but Derek's cross-examination was devastating. Miss Ashford, you've testified that you spent approximately 10 hours per week on HOA duties. Is that correct? Yes, sometimes more, Karen said. And you paid yourself $800 per month for these duties. It was compensation for my time and expertise. Did the HOA board vote to approve this compensation? Karen hesitated. It was discussed. Please answer the question. Did the board hold a vote? Not a formal vote, but there was general agreement. Derek pulled out meeting minutes. I have minutes from every board meeting during your presidency. Can you show me where this compensation was discussed and approved? Karen's face reddened. It might not have been recorded in the minutes. Or it never happened, Derek said. Miss Ashford, isn't it true that you unilaterally decided to pay yourself nearly $10,000 per year from HOA funds without proper authorization? I worked hard for this community. That's not an answer to my question. Yes or no, did you have proper authorization? I believed I had the authority to compensate myself for my time. Judge Foster intervened. Miss Ashford, please answer the question directly. Karen's voice was barely above a whisper. No formal vote was taken. Derek continued. And isn't it true that you've enforced rules selectively, targeting homeowners you personally disagreed with while ignoring similar violations by homeowners you liked? That's not true. Derek presented evidence from the discovery, showing multiple instances where identical violations received different treatment. Karen had no good explanation. The next bombshell came from an unexpected source. One of the other board members, Robert Chang, asked to speak with Derek privately during a recess. He came back looking grim. "We need to add Robert Chang as a witness," Derek told Judge Foster. Pemberton objected, but the judge allowed it. Robert took the stand that afternoon. "Mr. Chang, you've been on the HOA board for 3 years. Is that correct?" Derek asked. "Yes." "Why did you want to testify today?" Robert took a deep breath. "Because I can't stay silent anymore. Karen has been running the HOA like it's her personal fiefdom. She makes decisions without consulting the rest of the board. She's been paying herself without authorization like you established, and she's been using HOA funds for personal expenses." The courtroom erupted. Judge Foster gavelled for order. "Personal expenses. Can you elaborate?" Derek asked. "She's charged dinners to the HOA credit card, claiming they were business meetings, but I know at least some of them were personal. She's used HOA funds to pay for landscaping at her own property, billing it as neighborhood common area maintenance. When I questioned her about it, she threatened to remove me from the board. Do you have evidence of this?" I brought copies of credit card statements and invoices. Robert produced a folder. "I made copies before coming here because I was afraid she'd destroy them." Karen was on her feet. "He's lying. Your Honor, he's always been against me. This is revenge for Miss Ashford. Sit down and be quiet or I'll hold you in contempt," Judge Foster said sharply. Derek admitted the documents into evidence. Over the next hour, he and Robert went through them. The evidence was damning. Karen had spent thousands of HOA dollars on personal expenses, all disguised as legitimate HOA business. Pemberton tried to rehabilitate Karen on redirect, but the damage was done. The jury looked at her with disgust. The next day, Derek rested our case. Pemberton put on a brief defense, mostly arguing that even if there were governance problems, the underlying covenants were still valid. But the momentum had shifted entirely. Closing arguments were on Thursday. Derek was eloquent, tying together all the evidence to show that the HOA had operated illegally, had misused funds, and had no legitimate authority to enforce their aesthetic restrictions against my fence. Pemberton did his best, but he was working with a bad hand. Judge Foster instructed the jury on Friday morning. They deliberated for 4 hours. When they came back, the forewoman stood. "In the matter of Marcus Johnson versus Silverstone Heights Homeowners Association, we find for the plaintiff on all counts." Relief flooded through me. Sarah grabbed my hand and squeezed, but Judge Foster wasn't done. "I want to make some additional findings on the record. Based on the evidence presented at this trial, I find that the Silverstone Heights HOA has been operating outside its legal authority under Nevada revised statutes. Their governing documents are outdated and unenforceable as written. Furthermore, I find that Miss Karen Ashford has engaged in financial mismanagement and potential fraud in her handling of HOA funds." He turned to Karen. "Miss Ashford, I am ordering you to immediately repay all unauthorized compensation and personal expenses you charge to the HOA, which by my calculation totals approximately $14,000. Additionally, I am removing you from the board effective immediately. If you fail to comply with the repayment order, I will refer this matter to the Clark County District Attorney for potential criminal prosecution." Karen's face went pale. Pemberton tried to speak, but Judge Foster held up his hand. "I'm not finished. This HOA will not collect any fines or fees from homeowners until they have properly updated their governing documents in compliance with current Nevada law and had those documents reviewed by independent legal counsel. Any existing fines imposed under the old rules are hereby voided." Mr. Johnson and all other plaintiffs are entitled to their reasonable attorney fees and costs. It was a complete victory, far beyond what we had hoped for. The news coverage was extensive. That evening, I did interviews with 3 local stations and a reporter from the Las Vegas Review-Journal. The story resonated because so many people had their own HOA horror stories. In the weeks that followed, Karen resigned entirely from the board rather than face potential criminal charges. She paid back the money through her attorney. The remaining board members, led by Robert Chang, hired a law firm to completely restructure the HOA's governing documents, but the story wasn't quite over. 2 months after the trial, I got a call from Derek. "Marcus, you need to see this." He sent me a link to a local news article. The headline read, "Former HOA President Arrested for Embezzlement." The article explained that the Clark County District Attorney had opened an investigation after our trial. They discovered that Karen had embezzled more than $40,000 from not just Silverstone Heights, but from 2 other HOAs where she had previously served as president. She had used sophisticated accounting tricks to hide the theft, but once investigators started looking, the evidence was overwhelming. Karen was arrested and charged with multiple counts of embezzlement and fraud. According to the article, she faced up to 10 years in prison if convicted. I felt a strange mix of vindication and sadness. This had started over a fence color, but it had uncovered years of corruption and abuse of power. The preliminary hearing was held in November. Sarah and I attended, sitting in the public gallery. Karen looked diminished in her orange jumpsuit, nothing like the imperious HOA president who had stood at my door demanding I repaint my fence. The prosecutor presented evidence of the embezzlement from all 3 HOAs. The amounts were staggering when added together. Karen's public defender tried to argue for bail reduction, but the judge denied it, citing the severity of the charges and the risk that Karen might flee. As we left the courthouse, a reporter approached me. "Mr. Johnson, do you feel responsible for Miss Ashford's current situation?" I thought carefully before answering. "I feel responsible for standing up for what was right. If Karen chose to commit crimes, that's on her. But I'm glad that homeowners in 3 different communities will get justice and potentially get their money back." The trial for the criminal charges was set for early the following year, but in late December, Karen's attorney announced she had accepted a plea deal. She pleaded guilty to embezzlement and fraud, agreeing to make full restitution to all 3 HOAs and to serve 4 years in prison. The day of her sentencing, Judge Mitchell Rodriguez made a statement that the news channels played repeatedly. HOAs are supposed to serve homeowners, not enrich those who run them. Miss Ashford abused her position of trust and stole from her own neighbors. This sentence should send a message that such behavior will not be tolerated. Karen was led away in handcuffs. I watched the news coverage that night with Sarah, our kids already in bed upstairs. "It's really over," Sarah said. "Yeah, it is." Meanwhile, the Silverstone Heights HOA had been completely reformed. Robert Chang served as interim president while they held new elections. The governing documents were updated and approved by 90% of homeowners in a vote held in October. The new rules were reasonable, focusing on actual property maintenance issues rather than subjective aesthetic preferences. My sage green fence stood as a symbol of what the fight had been about. Several other homeowners painted their fences various colors, and the neighborhood actually looked more vibrant and interesting than it had before. The other 2 homeowners who had joined my lawsuit became good friends. Tom Reynolds, who had painted his fence blue, hosted a neighborhood barbecue in January to celebrate the new year and the new HOA. Nearly 50 families attended, far more than had ever participated in HOA events under Karen's leadership. At the barbecue, Robert Chang made a toast to Marcus Johnson, whose refusal to repaint his fence led to real change in our community. Sometimes standing up for something small leads to something much bigger. Everyone raised their glasses. I felt proud but also relieved that it was finally behind us. Derek's law firm started getting calls from homeowners across Nevada and even from other states. Our case became cited in legal briefs challenging HOA overreach elsewhere. The Nevada legislature introduced a bill in their 2027 session that would require all HOAs to review and update their governing documents every 5 years, directly inspired by our case. In March, exactly 1 year after Karen had shown up at my door with her clipboard, I was invited to speak at a conference on HOA reform in Reno. Standing at the podium, looking out at an audience of homeowners, attorneys, and even some HOA board members who wanted to do things right, I shared our story. "I never set out to be an activist," I said. "I just wanted to paint my fence a color my wife and I liked." But when someone tells you that you have to follow rules that aren't even legal, you have a choice. You can comply and hope for the best, or you can stand up and fight. I chose to fight, not because I'm particularly brave, but because it was the right thing to do. After my speech, dozens of people came up to share their stories. An elderly veteran who had been fined for displaying an American flag. A woman with disabilities who was told she couldn't install a ramp to her front door. A family threatened with foreclosure because their desert landscaping didn't meet the HOA's grass requirements, even though the state was in a drought. Each story reinforced why our fight had mattered. That spring, Sarah and I decided to update our backyard landscaping. We added a small water feature and some decorative rocks. Under the old HOA rules, we would have needed approval. Under the new rules, we just needed to make sure our modifications didn't affect drainage or property boundaries. We filed a simple notice with the HOA, and that was it. Robert Chang remained HOA president after winning the election in April. He ran the organization transparently, with detailed financial reports posted online monthly and open board meetings where homeowners could actually participate. The contrast with Karen's secretive, authoritarian approach couldn't have been starker. One Saturday morning in May, as I was watering my plants next to my sage green fence, a young couple walked by pushing a stroller. They stopped and introduced themselves. "We just bought the house 3 streets over," the man said. "When we were deciding between neighborhoods, we researched the HOAs. After reading about what happened here and the reforms that were put in place, we chose Silverstone Heights. We wanted to live somewhere with an HOA that actually served the homeowners." That moment drove home what we had accomplished. It wasn't just about my fence, or even about exposing Karen's crimes. It was about changing the culture of our community, and showing that homeowners didn't have to accept being bullied by petty tyrants with clipboards. The restitution from Karen came slowly, paid out as part of her plea agreement. Each HOA she had stolen from received monthly payments. Silverstone Heights used the returned funds to improve the community center and upgrade the playground equipment. In June, I ran into Patricia Nelson, Karen's former vice president at the grocery store. She looked uncomfortable when she saw me. "Marcus, I owe you an apology," she said quietly. "I knew something wasn't right with how Karen was running things, but I didn't speak up. I should have." "You were on that board for years," I said. "It wasn't quite a question." "I was. And I was scared of her, honestly. She had a way of making you feel stupid if you questioned anything. But that's no excuse. I should have been braver like Robert ended up being." What matters is that things changed, I told her. The community is better now, she nodded. It really is. My granddaughter comes to visit now and loves the new playground equipment. It's nice to actually be proud of the HOA instead of embarrassed by it. Derek stayed in touch, keeping me updated on the various cases around Nevada that were using our victory as precedent. Several other HOAs were forced to update their governing documents. A few other board presidents were investigated for financial mismanagement, though none of the cases were as egregious as Karen's. In August, I was invited to testify before a Nevada legislative committee that was considering the HOA reform bill. I sat at the witness table in Carson City and explained what our family had been through. The problem isn't HOAs themselves, I told the committee. The problem is when they operate without proper oversight and accountability. Requiring regular review of governing documents and mandatory financial audits would prevent situations like what happened in our community. The bill passed in September and was signed into law by the governor in October. It would take effect at the start of the new year. As fall arrived and the weather in Henderson finally cooled down, I found myself reflecting on the entire experience. It had been 18 months since Karen knocked on my door. 18 months of stress, legal battles, court appearances, and ultimately, vindication and reform. My sage green fence had held up beautifully through the scorching summer. The paint hadn't faded, and it still complemented our landscaping perfectly. More importantly, it represented something bigger than just a color choice. It represented the right of homeowners to make reasonable decisions about their own property without arbitrary interference. Sarah and I celebrated our anniversary in November with dinner at a nice restaurant on the Strip. Over dessert, she raised her glass to the fence that changed everything. I laughed and clinked my glass against hers. I don't think either of us expected a paint color to lead to where we ended up. No, but I'm proud of you, she said seriously. You stood up for what was right, even when it would have been easier to just repaint and move on. That takes courage. In December, I got a letter from the Nevada Attorney General's office. They had created a new HOA dispute resolution program, partly inspired by our case, and they wanted me to serve on the advisory board. I accepted. The program launched in January, providing homeowners with a way to resolve disputes with their HOAs through mediation before things escalated to litigation. It was exactly the kind of systemic change that could prevent other families from going through what we had experienced. Karen was transferred to a minimum security facility to serve out her sentence. I heard through the grapevine that she was teaching other inmates to read as part of a prison education program. I hoped that maybe she would come out of this experience a better person, though I would never forget the stress and anxiety she had caused my family. The anniversary of our court victory came in September. The Silverstone Heights HOA, now a model of good governance, held a community appreciation event at the park. Robert gave a brief speech thanking everyone who had participated in the reform process. Change is hard, he said, but sometimes change is necessary. What happened here shows that ordinary people standing up for their rights can make a real difference. We're a stronger, better community because Marcus Johnson wouldn't back down over a fence color. Everyone applauded. I felt both embarrassed and gratified by the attention. Later that afternoon, as the sun was setting and casting golden light across the desert landscape, I stood in my backyard looking at the fence. The sage green still looked perfect, maybe even better now with the weathering that came from 2 years under the Nevada sun. I thought about everything that had happened, all because of this one decision to choose an unapproved color. The lawsuit, the trial, The discovery of embezzlement, the criminal prosecution, the legislative changes, the reformed HOA, and all the connections I had made with other homeowners and advocates across the state. If Karen had just left us alone, if she had just let us have our sage green fence without making it into a federal case, none of this would have happened. She would probably still be stealing from HOAs. Homeowners would still be living under outdated and illegal restrictions, and communities across Nevada wouldn't have the new protections they now enjoyed. In a strange way, Karen's overreach had led to something positive, though certainly not what she had intended. My neighbor Tom called over the fence, his blue fence. "Hey Marcus, some of us are getting together next weekend to watch the game. You interested?" "Definitely," I called back. Life in Silverstone Heights had returned to normal, but it was a better normal. People were more engaged with their community. The HOA actually served its purpose instead of being a source of frustration, and homeowners felt empowered rather than intimidated. As I walked back inside, Sarah met me at the door. "Everything okay?" "Everything's perfect," I said, meaning it. The story of the fence would become part of our family history, the tale we would tell at dinner parties for years to come. The time Dad fought the HOA and won. But it was more than just a personal victory story. It was a reminder that individuals could challenge unjust authority, that systems could be reformed, and that sometimes the smallest spark could light a fire of real change. My sage green fence stood as a monument to all of that. Every time I looked at it, I remembered that standing up for what was right, even in the face of intimidation and threats, was always worth it. The fence was just a fence, but what it represented, the principle behind it, that was everything. In the end, Karen had no authority because she had never had legitimate authority in the first place. She had been wielding outdated rules and using fear to maintain control. When that was challenged, when someone finally said no and backed it up with facts and law, the whole house of cards collapsed. Other homeowners associations across the country reached out to learn from our experience. I participated in webinars and wrote articles for homeowner advocacy publications. The story spread far beyond Henderson, Nevada, becoming part of a national conversation about HOA reform. 2 years after painting my fence, I could look back and see the full arc of what had happened. What started as a simple home improvement project became a legal battle, which uncovered criminal activity, which led to conviction and imprisonment, which sparked legislative reform, which created systemic change. All because I painted my fence sage green, and someone with no legitimate authority tried to tell me I couldn't. The judge had been right when he said the HOA had no authority. They never had the authority they claimed. They had just been operating on assumption and intimidation for so long that nobody had challenged them. Until my fence. As I sit here now, writing this account of everything that happened, I can see my fence through the window. It still looks great. The color still makes me happy. And every time I look at it, I'm reminded that ordinary people can make extraordinary change when they refuse to back down from what's right. The Silverstone Heights Homeowners Association is now one of the best-run HOAs in Nevada, regularly cited as an example of how these organizations should operate. They serve their community instead of ruling over it. They follow the law instead of making up their own rules. And they respect homeowners' rights instead of trampling them, all because of a fence, a fight, and a determination to stand up against illegitimate authority. The judge said they had no authority, and he was absolutely right. They never did. They just acted like they did until someone called their bluff. My sage green fence proved that sometimes the smallest act of defiance can change everything.